SJC-13307, James Lyons, in his capacity as chairman of the Massachusetts Republican Party, and others, v. Secretary of the Commonwealth.
Okay, Attorney Walsh.
Good morning, Madam Chief Justice. With me here is Attorney David Carr, the General Counsel for the Massachusetts Republican Party, and Plaintiff Jim Lyons.
Morning, Ross. Morning.
Okay, good morning.
My time. Your Honors, in one of the amicus briefs presented by Common Cause, I was challenged that there was no specific statute, no specific section of the Constitution I could point to require an in-person presence. This requirement has been inferred into the word meeting, and if, with respect, that's wrong. Part 2, Chapter 1, Section 2, Article 2 has been heavily amended.
Can you slow down a little bit and also maybe get a little closer to your computer because you're hard to pick up?
Certainly. My apologies, Your Honor. With respect, Common Cause's brief is wrong. Part 2, Chapter 1, Section 2, Article 2, although it's been amended several times, still provides that the Senate shall be the first branch of the legislature, and the Senate shall be chosen in the following fashion, viz. There shall be a meeting, in brackets, forever of the inhabitants of each town, and if you'll forgive an ellipse, to be called by the selectmen and warned in the due course of law at least 7 days before for the purpose of electing senators and councilors. Also, in addition, the requirement of a personal presence was restated into Article 21 of the amendments, and that remained the law until that was annulled in 1930 by Article 71, the effect of which is that it was absolutely clear to the Constitutional Convention in 1917 that there were only one choice to appear in person for elections, and if that were not the case, then they needed additional authority to provide for absentee. Therefore, we assert that any kind of absentee or mail-in voting must comply with the strictures of Articles 45, 76, and 105, or else they are on their face outside of the authority of the legislature. As the court will know, the Supreme Court of the United States in Horn versus Department of Agriculture said that the Constitution is concerned with means as well as ends. And I appreciate dramatically the amicus brief of JLASA to the extent that voting is good.
Mr. Walsh, can we start with,
yes,
early voting for a second, right?
Certainly.
Every federal court has found that early voting is not violated by the provision in the federal Constitution that refers to a particular date, right? Every single case, right?
Yes, to my knowledge, Your Honor, absolutely. But okay, I believe all of the.
So why wouldn't we? I mean, I understand we interpret our Constitution separately, but we've also interpreted early voting to be consistent with that provision, providing for a particular date, correct?
This court in Goldstein and in Grossman found the provisions to be reasonable under the sliding scale test. The question that we are proposing to the court is a slightly different variation, which is it within the power of the legislature, or is it something that they've been affirmably denied?
Right, but the legislature, again, has very broad powers in this area, correct? Unless, as you were arguing, Article 105 somehow precludes early voting and no excuse voting, right?
Yes, although I'd also add in that provision I cited earlier about the Senate vote being chosen by a meeting still in effect.
Okay, so let's start with, so the absentee voting created 3 exceptions, right? Three express exceptions to in-person voting, right?
Yes, sir.
For people out of town, for the disabled, and for people with religious exemptions. So those groups were given sort of a special dispensation, right? They were.
Yes, sir.
But here, we're not dealing with, and during the debates, there was a real focus on favoritism, who would get it. For example, there was a debate about whether servicemen would get it versus laborers. And so there was an issue of sort of selective treatment. Here we don't have that, right? This enhances for everyone the right to vote equally, right? Everyone can do mail-in voting. Everyone can also do early voting, right? Everyone has that option, right?
The statute is written absolutely as universal, no question about that.
So is that different we're not dealing with the same types of issues that we're dealing with 105.
Proceeding from the idea that every word in the Constitution must have meaning, when Article 105 and its two predecessors say that the legislature will have the power to do X, they are necessarily saying that there is no power to do anything that's not X. And I appreciate that there is a general grant, a residuum of power for the general court to make all wholesome and appropriate laws, including relating to elections. But if the 1917 convention found it necessary, and the voters agreed, that there was additional authority required to do anything other than meet in person and vote in person, and that being the background at which those amendments are adopted, that has to continue to be the rule. Otherwise, we've effected a constitutional change by statute, which, as your honors are aware, is not cricket.
So I think I'm having a little difficulty when I look back at the 1917, 1918 Constitutional Convention. And we have a class of absentee voters. We have no reference to early voting. We have no reference to mail-in voting. And when you consider the plenary authority of the legislature in this area, and that negative implication really shouldn't apply to constitutional interpretation, how is it that Article 105 precludes this early voting?
With respect, Justice Lowy, I would tend to disagree with the idea that we don't apply negative implication to constitutional interpretation. At least the popular branches of the government have over the centuries. We have more than 120 exactly amendments, and the majority of those, other than elections, deal with granting the legislature specific grants of additional power to preserve parkland, to protect historic monuments, to provide for provision of supplies in wartime, to provide for continuity of government. And so whenever, because we have this long history of the constitutional amendments going back and granting the legislature more power, despite their very wholesome general grant of power, it's clear that this court has, and popular branches as well as the electorate have over centuries treated this as a relatively narrow grant to the legislature. And therefore, I tend to assert to your honors that from the structure of the amendments, you absolutely can read that there is negative implication. Otherwise, we wouldn't need to keep going back and giving power to provide for parkland or to provide for zoning districts or to provide for voting machines or any of that like. These additional grants of power come because they were needed.
Council, what does the plenary power of the legislature mean then in your estimation?
In my estimation, it is an interstitial power to fill in the gaps that are not expressly provided. And so whereas here there's an express provision for absentee voting and secondly, an absolute provision for the election of senators in a meeting, the legislature can for example, voter registration is a complete statutory creature. It is not mentioned in the Constitution at all. We have absolutely interpreted that to be a useful affectation of deciding. Matter of fact, the initial case that first held voter registration to be constitutional was asked to rule against it based on the idea that it was adding additional qualifications that you had to be registered to vote. And this court decided that it was part of the plenary power of elections because it didn't determine who could vote. It only required that you get yourself specified on a roll in order to be able to vote. It didn't block the power. Here, we're asserting that the legislature is taking a power which the Article 17 convention had, or the 1917 convention had the right to grant, but didn't. In 1917, they understood that you absolutely positively had to be voting in person. And so after much discussion and partisanship and discussion about drawing lines between soldiers overseas or railwaymen or what have you, they eventually decided to adopt a universal amendment, but there is negative implication that flows from that, both from the text and from the world as they knew it in 1917. Literally, Article 21 was still in effect at that time, and meetings were required for electing senators as well as for senators specifically.
But I
So
understand.
to answer, sorry, Justice.
No, go ahead. No, go ahead, Justice Lynn.
So in answer to my question, you read the plenary power to be limited to filling in gaps related to these three particular types of absentee voting?
Yes, Your Honor.
So the plenary power is actually a quite limited power in your view.
It's a power that provides for the ability to specify polling stations and provide for the divvying up into precincts in addition to the constitutionally required districts. It is a very broad power, much the same way that this court's power to read law is one of the three co-equal branches. The interstitial gaps power to interpret a residual. As Your Honors will know from probate cases, the residual clauses are always where the money is, even though the specific bequests are ironclad and can't be moved. We're attempting to assert here, if you'll follow the analogy, that Article 105 is a specific bequest of power to the legislature, and therefore you cannot erect a parallel, substantially identical scheme without modifying the specific grant, because otherwise the residual would eat the whole of the specific grants of power.
I see that if you're talking about, if we created the right to absentee voting for firefighters because they work 12-hour shifts, or policemen, if they try to do that by statute, but we're dealing with something totally different. I mean, we're dealing with early voting. It has nothing to do with voting absentee. You're voting in the polling place. I mean, why would we apply a negative implication to early voting? I can see maybe on the mail-in, but the early voting seems to have nothing to do with the Article 105.
With respect, Your Honor, let's suppose that in 1919, immediately after the amendment was adopted, you were going to vote early because you couldn't get to the polls. The only other way to vote before the polls is to vote early. Therefore, just by implication of that 1917 voter, you absolutely know that absentee voting was intended to let people write their ballot and trust it to an elected official to be early so that it would be counted on election day. This, however, derogates from that because it's not only allowing the voter to cast early and trust the election official, it also, even as we pointed out in our brief, allows the votes to be put into the tabulator or the ballot box early, rather than kept in envelopes and put in. It takes away from what the Article 45 in 1917 was intended to do. Article 45 in 1917 absolutely provided for early voting because it's the only way physically that you could vote out on elections without being at the polls on election day. And that's literally what absentee means. But it was all early voting to a fashion. Therefore, the general early voting the legislature has now enacted has to comply with these strictures. It may just be that they have to print on the box that, you know, check one of these three boxes, and it may that when the ballot applications go out that they don't they may request that the voter pick an excuse, but that has to be there. That's indispensable.
So
You mean a reason? You mean a reason, not an excuse?
Yes, my apologies. Yes, a reason. Yes, my apologies. As your honors are,
so we've been doing mail-in voting for is it 8 years now? Excuse me, early voting for 8 years now. So every
Yes,
every one of those elections was illegal in your view?
those elections, the challenges that could have been brought to those elections were waived by not being brought. However, Your Honor is familiar with case law that decisions, no matter how wrong or how old or how bad, if they're bad, they deserve to be overturned. This was the rationale of the Supreme Court when they overturned Bowers versus Hardwick in Lawrence versus Texas, for example.
It's also
Bad
what they used in Dobbs, so I'm not sure it's a good argument.
I'm stuck with the tools that I'm given, I'm afraid. This court has language in its
We don't
history,
have better
I believe,
tools for you? We must. We
You
must.
have much better tools. The Declaration of Rights
Use
is one of
those.
the. Yes, Your Honor. This court, I believe, in a 1968 case, I'd have to cite it, said that a decision, no matter how bad decision, no matter how old, deserves to be overturned because we pick the moments in front of now. That's part of the cases of
Before we
controversy.
lose you, Mr. Walsh, just one last question. None of this applies to primaries, right? None of it.
We acknowledge
The constitutional provision you cite only applies to elections. All the cases only apply to elections. So you have no argument on the primary except for your severance point, right?
Other than noting the severance as well as the Bush versus Gore problem, no. And that's a statutory interpretation problem. Not a
I don't know
constitutional.
I don't understand what the Bush versus Gore problem is.
It essentially boils down to the idea that the legislature isn't obliged to give a right to vote, but when it does, it has to do so equally. And to do so
Can
otherwise,
I-
imagine.
Council, can I ask you to slow down and say that again? What, because I had the same question as Justice Gafker.
The legislature is not required to extend the right to vote in a primary. It used to be done by convention. But if you do extend the right to vote for primary, you have to extend it on an even keel basis. God forbid that this court should interpret the law to apply to primaries and not general elections.
Yeah,
Then
I
primary
read your,
vote, partisan
read your,
voters.
I read your brief on that. I just don't understand it. Because it applies to everyone equally in the primary. Your argument is essentially somehow that primaries are marketing opportunities for the parties.
That is an effect.
Go ahead. Mhm.
That is in effect what they become, but they're also a state subsidized poll. They're the government under the guise of a function with an official ballot. If it were not, if the primaries were struck in whole, this would be done by Mr. Lyons and his friends at a convention out in Worcester.
You
instead
gotta,
of being in a
you gotta
state
explain
organized.
this, Mr. Walsh, you gotta explain this a little to us because your brief doesn't make any sense on this point. So tell, what do you mean that, okay, so there's gonna be a primary, and how does a primary, how are people being treated unequally? There's a Republican primary, there's a Democratic primary, and write-in voters are gonna write in the same, have to be written in the same way no matter what. So I'm just confused about how this is unequal.
If I'm a voter in a primary election who, for whatever odd reason, decides that I don't vote in general election, maybe I'm discussing with the parties, or I don't like the choice between Hillary Clinton, Donald Trump, or anything under a million suns. If I choose to vote in the primaries, but not the general election, if you interpreted the law in the fashion, and I'm not saying that you shouldn't, just that there are technical issues to doing so, that my rights as a primary voter, my ballot would come to my door in a way that it shouldn't in the general election. And the this court, in opinion of the justices.
I
How does
don't
that-
follow that. I don't understand. Maybe I'm just not getting it, but I just don't follow that.
If I'm a primary voter as distinguished as a class from general
Right.
election voters, the legislature, if the enactment stays as is, I would receive benefits like an engraved invitation to vote by mail or absentee that I wouldn't receive in a general election under the strictures of Article 105.
And how
How-
would that be unfair or unconstitutional
Or unequal.
or unequal, right?
I don't know that it's unfair. I just note that it's a distinction which under Bush versus Gore, which is still a watershed case that's still finding its legs. I don't on
I
it.
think they said it
Bush
has
versus
no
Gore
legs.
stands.
They said it was limited to itself.
They did indeed, and then they promptly turned around and continued to apply it as ever. The short answer is that I'm not sure about applying it in primaries. We wouldn't, as a whole, object to that, but we note that there are some problems with interpreting the statute that way. We wouldn't want the court to avoid one constitutional error for the fear of creating another one. That's all.
Chief, could I ask one additional question, please? Thanks, Chief. So I want to just ask a question about what seems to be a premise of the litigation, which is that somehow Article 9's right to a free and equal election is implicated here. And where's the support for that? Where is the support that allowing qualified voters to vote early is somehow going to impact the fairness of the election or promote fraud? Where is that support that hasn't been provided in what's been submitted or in any other litigation that Justice Gafker referenced earlier on in one of his questions?
Your Honor, the primary, it is not an allegation that fraud is occurring, merely that it's susceptible to it. That comes primarily from a 1999 Massachusetts Appeals Court case by the name of Frinctus, which is cited in our motion for a temporary restraining order. And it says that because voting absentee or not in person is of a physically different kind, that it constitutionally is privileged as much, but it requires a separate it requires some separate guarantees and is necessarily, at least in administration, treated differently because of the potentials the physical reality potentials of fraud. Not we're saying that we have any evidence of it, and we certainly didn't, I hope, say that in our complaint, merely that it's, as a system is more susceptible to different kinds of errors, irregularities, or frauds than voting in person.
Okay, is everybody else set?
One last question. Did you cite that case in your brief? Because I don't see it. What is the
I
case
did not.
called?
I did not cite it in my brief. It is cited in the temporary restraining order, Your Honor.
And
It is.
What's the
Frank
site?
Apologies, Your Honor. I have it right here. The case is FYNTRILAKIS versus the City of Springfield, site 47, Mass App Court, 464, and the block quote in the temporary restraining order motion comes from page 472, and it is a 1999 case.
Okay, thank you very much.
Thank you very much.
Attorney Hornstein.
Good morning, Your Honors, and if it pleases the court, Assistant Attorney General Adam Hornstein. My pronouns are he, him, his, and I'm joined today by my colleague, Assistant Attorney General Ann Sturman, and we are here today on behalf of the Secretary to urge this court to affirm the constitutionality of the Votes Act, which expands the rights of voters to participate in the upcoming elections. I'd like to begin, if it pleases the court, by attempting to answer Justice Wendland's question about what does plenary power mean. Plaintiffs would have you believe that plenary power means that the legislature just gets to fill in some interstitial gaps, but that is not what plenary power means. Under longstanding precedent from this court, particularly in the context of regulating elections, the legislature retains broad power to act absent any specific circumscription of that authority by the Constitution. And here, respectfully, Article 105 contains no explicit limitation on the legislature.
One thing I was intrigued when I read that sentence, but that sentence about specific doesn't appear in any cases. That's you, as far as I can tell. I understand, the plenary power point, and you can't have something that contradicts the Constitution, but this express specific language, is that in any cases, or is that just your gloss on it?
Respectfully, Your Honor, that is my gloss on the opinion of the justices from 1971 and the opinion of the justices from 1975. I don't believe they use those particular adjectives or adverbs, but going back to the 1971 case, for example, and this is a quote, where the court emphasizes that, quote, except where the Constitution makes express provision, the legislature has broad powers to deal with elections. Again, respectfully, the Secretary's gloss is that the phrase express provision says that unless the Constitution says otherwise, the legislature retains the authority to regulate voting in the Commonwealth, Your Honor. So that is the language upon which the Secretary is relying in its brief, and it is quoted on page 27 about respectfully.
So the plaintiff's argument is essentially that, okay, 105, defines sort of the group that can vote absentee. Mail-in voting, I'm less focused on in-person, early voting than I am mail. Why isn't this sort of an expansion of the mail-in voting provision? Because I don't know if Mr. Walsh's description of history is correct, but he says, look, the only way you did absentee balloting in the past, would be mail-in voting, I guess, or maybe I guess he was saying the opposite. It was in-person voting, but why isn't this an expansion of that? Can you help us on that, just to clarify?
I will attempt to do so, but in order to do so, let me just ask a brief clarification. Is your question, why isn't early voting by mail just an extension of absentee voting as a species? Is that the court's question?
Yeah, just absentee voting. We're why isn't this an expansion of 105 as opposed to a different, something quite different? Because it has an element of both. It's both different and an expansion, right?
Yeah, I respectfully would agree that yes, it is both different in some respects, and in some practical respects, the two do look rather similar. But I think there are several responses to that. One is the response that Common Cause offered in its amicus brief, which is to emphasize that Article 105 and its predecessors were designed merely to clarify that the legislature always had this authority to allow for absentee balloting. But given the shift away from in-person town meeting style votes towards the more modern ballot box style, it needed a clarification amendment to make that clear.
I get the Common Cause brief is intriguing in that way, but it also it supports Mr. Walsh's argument a little bit too, that you had to make a constitutional correction, right?
I wouldn't say it's a constitutional correction. I think what we characterize it in our brief is setting a constitutional floor, Your Honor. And I think Your Honor asked a question of Mr. Walsh, which is some version of, I forget the exact wording, isn't there a constitutional right to vote absentee? And 2 years ago in the Grossman case, the court recognized that there was no constitutional right to vote by mail, which seems to distinguish voting by mail from the concept of absentee voting altogether. And this is, I think, further to Justice Lowy's point that early voting or early voting by mail wasn't even on the minds of the framers during the 1917-1918 Constitutional Convention. So though there may be some practical similarities between what is considered absentee voting and what is now considered early voting by mail, the two have a different origin, the two have a different genesis, and the legislature, because the Constitution set this floor for absentee balloting, didn't say that the legislature couldn't go beyond that to allow for more people to participate in a free, fair, and orderly election in the Commonwealth. And that is the case here, Your Honor, the Commonwealth submits, is that this is just a different form of balloting, as the court recognized 2 years ago. And because of that, where the legislature retains plenary authority, the ability to do more unless the Constitution explicitly says so otherwise, there is no Article 105 problem with the Votes Act, respectfully. That is the Secretary's position here.
I have a little trouble with it's just a floor. I mean, so if the Constitution says you have to be 18 to vote, they can't provide a statute that says 16-year-olds can vote, can they?
If the Constitution says that, I guess it would depend on how the text of that amendment were framed. And if the Constitution said that everybody has to be 18 and older to vote, then that would seem to me to be an express limitation on the legislature's authority. But again, that is not the case here, where the Article 105 sets a minimum for what the legislature either should or can do.
But it doesn't say it sets a minimum. Again, that's your gloss on what it's doing, right? It's a little harder than that, right? It doesn't just say that. We've got to sort of piece it together, right?
Yeah, that's correct. We do have to piece it together. And the way that the Secretary submits that the court should piece it together is by starting with the text of Article 105 and coupling that with the idea of plenary legislative power. Again, unless there is an express restriction in the Constitution that says that the legislature cannot so act, then we start from the premise that the legislature can act or can do more.
Okay, so take my hypothetical then. So we have Article 105. Can the legislature create exceptions for medical personnel because they have to work in the hospital that day? Is that an express? Can they just add any group they want?
It is a far I apologize, Your Honor. It is a far closer question because there we are dealing specifically with absentee balloting, not early voting by mail, which is a different type of voting, I would submit. But in your hypothetical, Your Honor, could the legislature do more with respect to absentee balloting? Again, this is a far closer question, but starting from the premise that the legislature can always go up from the floor, I think the answer is probably yes, though I will confess it is a closer question.
Really? Doesn't that invite selective preferencing? Isn't this saved because everybody gets this? I mean, everybody can vote early. Everybody can do mail-in. There's no.
Correct.
It's an enhancement of the right to vote for everyone in the Commonwealth.
Correct. And let me clarify my earlier answer. I wasn't answering it with respect to, I think, a separate constitutional issue, which would be selective preferencing. I think Your Honor is correct to observe that creating absentee balloting for firefighters or for police officers might have a constitutional problem from a selective preferencing standpoint. But I don't know that that is an Article 105, qua Article 105 problem. But here, as the court observes, where early voting and early voting by mail are made broadly available to anybody who wants to participate, that diminishes that constitutional issue. And again, I think underscores the idea here that what the Votes Act seeks to accomplish by allowing qualified voters to vote, just as it did in 2020, just as happened in 2018 and 2016, is a permissible thing for the legislature to have done.
Can I shift you? I don't mean to change subject. My colleagues have further questions on this particular point. I just wanted to get some clarification on a couple of the other provisions. So I'm a little confused about the ballot worker provision. So if there's sort of this interim stage, up front, you have to have both parties as observers, right? There's a Republican and a Democratic observer in the first part. And then on the last day, there's also a Republican and a Democratic observer, but there's this 6 weeks before there's a problem, there isn't. Can you give me a rational basis for that? So I just understand the logic of it.
Sure. Let me just maybe walk the court through how this process at least works in theory, and emphasize that this is not poll observers, but these are poll workers. These are the people who administer the elections, not poll watchers.
Okay.
So what happens is before an election, local town officials will ask local party committees to submit to them lists of people to serve as poll workers. And sometimes, particularly in smaller communities, those lists are never even generated just because there aren't enough people who are enrolled and willing to serve in that role. And as a result, sometimes there are positions that need to be filled so that voters can vote on election day. So we need these poll workers to facilitate the well-working of elections. Now, 6 weeks before the election, that data.
But break it into the three parts, because the first part, right, you have to pick those poll workers from the Republican and Democratic lists, right?
Again, it provided the lists are submitted, yes.
So, but if they're not submitted, I just thought that at the first and third stages, you have to have Republican and Democratic poll workers. But then there's this interim stage where you don't have to. I'm just trying to understand the rational basis for that, because everything needs to meet a rational basis test, right?
Right. The court is correct that everything needs to meet a rational basis test. And the court is also correct that the Votes Act did not amend Chapter 54, Section 16A, which pertains to same day replacement of poll workers. Again, that's, if we could find somebody at the 11th hour to serve as a poll worker.
But it's not an if, right? They have to on that.
They should. Theoretically, it is mandatory. Again, in practice, I can't speak to how that works.
So it's mandatory that there's going to be this dual partisan it's mandatory at the first and third stages to have a Republican and Democratic poll workers. It's in this middle stage that it's not mandatory, right?
Correct. So what the Votes Act does is amends Chapter 54, Section 14 to allow, and this is the 6-week period, to allow poll workers to be appointed without regard to party status or inclusion on a local party committee's list. And the reason that there's that 6-week period is so that there is ample time to train up these poll workers so that they can perform their job. But fundamentally, Your Honor, what is at the heart of plaintiff's allegation here is the idea that somebody's party status affects their ability to fairly, neutrally, and dispassionately discharge their oath as poll workers. Now, you could walk into any polling place in this Commonwealth and be unable to discern who the Republican poll workers are and who the Democratic poll workers are because they all take the same oath. They all perform the same jobs.
Right, but there's an element that to ensure the integrity of elections, right, that we have this balance, right? Otherwise, it doesn't make any sense.
Well,
right?
the legislature has to balance both that interest and the interest, Your Honor, in having polls fully staffed. Again, this is more an issue in smaller communities or communities in which local parties do not even submit lists because they don't exist or have volunteers who are willing to serve in that capacity. So what the legislature is doing here and why it is rational, and I think this is the question that we've ultimately wound our way to, is why draw these lines? And the answer is this reflects the legislature's best judgment on how to balance the interest of creating a fair election with the legislature's interest in having.
I get that. What I'd like you to do is refine what you just said and explain to me how it works with these 3 different parts, okay? Because the second part is treated differently than the first and the third, right?
Correct.
So
Correct.
is there a rational basis for that?
So if the question is, do I understand the legislative history of why the Votes Act did not change Section 16A? There is no legislative history on that point. However, given the legislature's, again, ability to balance these competing interests, I can certainly see that the legislature could rationally make the decision that it's important to have polls staffed. And so they have this sort of middle period where they're trying to get unenrolled people or people from either party to serve in that capacity. But on day of, there is a preference given to finding a replacement of the same party for the person who just departed. But again, I will emphasize that there is absolutely nothing in the complaint that would suggest that poll workers, regardless of political affiliation, can perform their job or don't perform their jobs according to their oaths. So under those circumstances, I think plaintiffs have not carried their burden to show that the law is irrational here, even though there are these 3 different periods that sort of bounce back and forth, as the court rightly observes.
Can I ask one last question, Chief? So Mr. Horns, can you take so we're extending the buffer zone period quite dramatically. So in the old days, the buffer zone was only for 1 day, essentially. Now it can be as long as 10 days, or I can't remember, 2 weeks?
2 weeks.
Are there federal cases that talk about early voting and the buffer zones that we can look at that say that this type of buffer zone for this extended period of time does not violate the federal Constitution?
So, Your Honor, I am not aware of any specific federal case authority dealing with buffer zones for early voting polling places. The best authority that I could point the court to is the Supreme Court's decision in Burson and the follow-on decision in Lemansky.
That's just a single day case, right?
Correct. That Burson dealt with the Tennessee 100-foot buffer zone around polling places on election day itself. That is absolutely correct. If the court would like, I'm happy to expound on that, I realize I'm short on time, but if the question is just, is there any case law on it? There may be, but I am unaware of it.
I'm just trying to understand. So we've got these smaller towns in Massachusetts where the town hall is basically the single public forum, or is that and it's going to be shut down for 2 weeks or so at least, right? So
Well, it would be, at least with respect to the polling place itself, the polling place is a non-public forum on these early voting days. And make no mistake, when somebody comes to cast a vote early at a polling place, it works almost entirely as it does with respect to casting a ballot on election day itself. And both the plurality decision in Burson and even Chief Justice Roberts' decision in Mansky emphasize that in those last 15 seconds before somebody walks into a polling place and casts a ballot, that is a time for choosing and not campaigning. That's a time for sober reflection where somebody can cast a ballot free from electioneering. And although
okay, I get the one last point. There's a factual error you've agreed to, right? You talk about 100-yard buffer zone. It's really 100 feet, right?
It is feet. If we included yards, I profoundly apologize given the press of time. We are dealing with 150
I get
foot.
it. This has been a long weekend for everybody. So
And I'm extraordinarily grateful to both the court, its clerks, and its staff for agreeing to hear this case on such a compressed time frame. Thank you very much.